So ang papag-usapan po natin today is yung latest update po sa ICC case ni FPRRD. So unang-una po dyan, kung maka-apekto ba itong pag-step aside ni Prosecutor Khan dun sa kaso niya. And then i-discuss ko din po yung pinaka-recent na final na pleading po nila Attorney Kauffman on May 9, 2025 dun sa pag-request for the disqualification of 2 judges. Okay, so good everybody po. This is AttorNEIL Abayon, your quote-unquote favorite DDS lawyer, at yan po yung i-explain ko sa inyong lahat for today, okay? Pero bago po tayo mag-explain, konting maritesan lang po muna tayo. So sa lahat po nang nagko-comment sa recent post ko na tumakbo daw ako ng 2028, ang masasabi ko lang po, wag nyo muna problemahin po yung 2028 kasi sobrang layo pa po nun, di ba? The Philippine elections, the midterm elections just concluded last Monday lang. 1 week pa lang po yung lumipas. So tsaka na po natin problemahin yung 2028. So for now po, focus lang muna tayo dito sa legal educational videos ko to current events. Dito lang po muna tayo, tsaka na po natin isipin yung 2028. And gusto ko lang din po pala i-welcome lahat ng mga bagong subscribers, members, and followers ko po all across my social media. Kasi last week po we were only at 155,000 more or less sa YouTube ko, then in a span of 7 days, in a span of 1 week, bigla po yung tumalo ng 205, more or less around 205,000 na po ngayon. So that is my biggest jump po in a span of 1 week. Never po yan nangyari. So gusto ko lang po kayo i-welcome lahat dito. Hopefully you enjoy my content, may matutunan po kayo. At sa lahat naman po ng mga old subscribers ko, let us welcome po the new subscribers, the new members, and the new followers po, para at least we can all appreciate the legal content, the legal videos that I make regardless po of our political affiliation. Okay, so yan naman po yung goal ko dito. Huwag tayong mag-away-away. Rather, may matutunan po tayo at ma-appreciate po natin kung paano gumagana yung batas po natin sa mga current events po dito sa bansa natin. Okay, so ngayon tuloy na po tayo sa discussion. Okay, so yung first question po natin is kung ano ba yung epekto nitong pag-step aside ni Prosecutor Khan dun sa kaso ni FPRRD. Okay? So ang sasabihin ko lang po, dediretsuhin ko na kayo, hindi po ito maka-apekto sa kaso ni FPRRD. Kasi yung functions naman po ng prosecutor does not attach directly to the personality of the prosecutor. Rather, it attaches to the office of the prosecutor. Okay? So si Prosecutor Khan po, kahit na po nag-step aside yan siya, tutuloy pa rin kasi meron namang mga assistant prosecutors dyan sa office of the prosecutor. Pwede rin po actually mag-appoint sila, let's say, ng acting head prosecutor. Kung makita po ninyo, tutuloy at tutuloy pa rin po talaga yung kaso. Okay? So gusto ko lang yan i-emphasize kasi baka may nababasa po kayong mga posts sa sinasabi hindi natutuloy kasi yun nga, nag-step aside na to due to sexual misconduct. Again, hindi po yan ganon. Because the function of the prosecutor is attached to the office itself and not directly to the personality of the prosecutor. Okay? And the reason kung bakit ganyan po yan, bigyan ko po kayo ng example para mas ma-visualize nyo. Kung ang functions ng prosecutor attaches to the personality, sobrang dali po yan abusuhin or ma-exploit po ng mga akusado na talagang may criminal intent, 'di ba? Kasi kung isipin po ninyo, kung gusto lang mapatigil ng akusado yung isang kaso, edi pwede lang niya ipapaya yung prosecutor para matigil na kung yung functions pala is naka-attach talaga dun lang sa taong yon. And yan po yung rason kung bakit yung function itself attaches to the office and not to the personality of the prosecutor. Okay? So ang next issue naman po natin is itong related sa pag-request po nila Attorney Kauffman para magpa-excuse yung dalawang judges. So ito po hindi na to bago actually. May 7 pa to siya nangyari kasi nung May 1, di ba, nag-file po sila Attorney Kauffman nung defense in relation to the jurisdiction. Ginawan ko po yun ng video, di ba? Tapos pag-file po nila nun, may sinabay din silang invitation na para daw magpa-excuse yung dalawang judges. However, ang sinagot po doon ng ICC chamber is that hindi daw yun possibility, the possibility for that person to invite or request judges to seek excuse is thus not contemplated in the statutory text. So ang sinabi lang naman dito, wala daw ganung proper remedy. Hindi pwede mag-invite para magpa-excuse yung judges ang defense. Kasi yun nga, it is not in the statutory text. Wala daw po sa batas under the Rome Statute, okay? Pero hindi po ibig sabihin nun is na-deny yung defense to jurisdiction nila FPRRD. Yan po yung gusto ko lang klaruhin regarding this answer po or this decision nung ICC chamber, okay? So ngayon punta naman po tayo sa next issue natin. So ngayon, ito na po yung pinaka-recent na final talaga nila Attorney Kauffman in relation dun sa case po ni FPRRD. This was filed May 9 pa po. At yung pinaka-purpose po nito ngayon, di ba sabi dun sa initial yung sa May 7, hindi daw pwede mag-invite yung defense para magpa-request ng excusal yung judge. So dito ngayon, hindi na invitation yung ginawa talaga nila Attorney Kauffman. Nag-file na po talaga sila ng request for the disqualification of the judge directly. So itong final nila proper na po kasi nasa Rome Statute na talaga to. Pero para po mas maintindihan ninyo, i-explain ko muna yung backstory kung bakit nire-request talaga nila Attorney Kauffman ipa-disqualify itong dalawang judge, sila Judge Rene Adelaide Sophie Alapini Gansu and si Judge Maria del Socorro Flores Liera. Ang haba po ng pangalan nila, no? So anyway, explain ko po muna sa inyo yung backstory. So yung pinaka-reason po is because of this one talaga, itong kaso po sa Appeals Chamber sa ICC. So dati po kasi may kaso dyan sa Appeals Chamber kung saan sila Solgen Guevara pa po yung nag-represent ng Philippines back then, na dinesisyonan nila nung 27 March 2023. Dininay po nila yung question on the jurisdiction nila Solgen Guevara. At dun po kasi sa case na to, ito pong case na to, kasama po tong sila Judge Socorro Liera and si Judge Rain Alapini Gansu. Kasama po kasi silang dalawa dun sa decision kung saan dininay po yung defense of jurisdiction nila Solgen Guevara. Okay? So because of that po, because of this 2023 decision, yun yung reason kung bakit ko ni-question ni Attorney Kauffman yung dalawang judges or gusto po niya ipa-disqualify, because from there, yung appearance of impartiality or pagiging impartial ng two judges na yun is pwede po maging questionable daw in the eyes of a reasonable person according to Attorney Kauffman. Okay? Ang problem lang din po pala dito sa case na to, ang issue po nila Solgen Guevara talaga dito relied heavily on the lack of jurisdiction. Pero yung argument po na ginamit ng ICC Appeals Chamber is yung kaya daw nila dininay kasi there was a failure to prosecute or unwillingness dun sa pag-prosecute kay FPRRD. So of course, during this time, there was really a unwillingness or a failure to prosecute against FPRRD considering magkaibigan pa po si FPRRD pati yung sitting president by this time eh. Pero again, like what I've explained in my previous ICC video, since ngayon hindi na good terms sila PBBM at si FPRRD, sa tingin ko hindi na po magkakaroon ng failure to prosecute if ever tinuloy talaga yung prosecution po dito sa bansa natin. Pero anyway, that's going to be a completely different topic kasi issue on admissibility na po yun. Haba na po tayo masyado pag-explain ko pa yun. So kung gusto niyo po panoorin yun, may video na po ako about that. Hanapin niyo na lang po sa playlist or ilalagay ko na lang po yung link somewhere dito. So ngayon, yan po yung backstory. Okay, again, i-summarize ko lang para mas maintindihan po ninyo. On March 27, 2023, the Appeals Chamber rejected the request of the Republic of the Philippines for suspensive effect of Pretrial Chamber 1's decision. So again, this is in relation po dun sa issue ng jurisdiction ng ICC over the Philippines. Kung saan itong judge po, si Judge Liera and si Judge Alapini Gansu ay kasama dun sa decision kung saan pinaboran po nila na may valid jurisdiction talaga yung ICC over the case po ni FPRRD. Okay? So ngayon na alam nyo na yung backstory, mas maintindihan nyo na po kung bakit pinapad-disqualify talaga nila Attorney Kauffman yung dalawang judges. Okay? So anyway, unang-una po i-verify muna natin yung document natin kasi baka sabihin nyo fake news po tayo eh. So this one sa upper left, you can see it's International Criminal Court and then dated May 9, 2025, addressed to the Presidency, and then the purpose is the request for the disqualification of the two judges, and then it is defense for Mr. Rodrigo Roa Duterte. Okay? So kung gusto nyo po makuha yung official copy nito, ilalagay ko na lang po yung link either sa comment section or sa description box po. So ngayon, punta na po tayo sa main argument sila Attorney Kauffman. So take note po sila Attorney Kauffman po yung gumawa ng arguments na to, hindi po ako. I am simply explaining it in layman's term para mas maintindihan ninyo kung ano ba yung mga legal principles dito sa ginawa po nilang pleading na to. Okay? So before po isa-isahin ko tong pleading na to, ito muna yung gusto ko i-explain sa inyong lahat para ma-gets nyo talaga yung importance kung bakit kini-question or gusto ipa-disqualify po nila Attorney Kauffman yung two judges. Sa role po kasi ng judges, ang kailangan po talaga nila mapakita is that they are not only actually impartial but they must also appear impartial in the eyes po of a reasonable person. Diba? So makita po niyan dito, ginamit po yan nila Attorney Kauffman. Tingnan po niyo dito, ang sabi po ni Attorney Kauffman, need not demonstrate actual bias but the mere appearance of grounds to doubt judicial impartiality suffices. Okay? So in Tagalog po, in simpler terms, ang ibig sabihin po niyan, ang mga judges po hindi lang dapat maging actually impartial or dapat hindi po sila bias, pero kailangan din po nila na pagtingnan po sila ng reasonable person is mukha talaga silang impartial or hindi bias. Yun po yung requirement talaga ng judges. So sa international laws po natin, sa Rome Statute, ganun po yun. Dito po sa bansa natin, ganun din po yun yung sa Code of Judicial Ethics natin. Judges must not only be impartial but they must also appear impartial. Dapat yung appearance mo po talaga in the eyes of a reasonable person is walang kaduda-duda na hindi ka talaga bias, 'di ba? So yun po yung requirement talaga in relation to the impartiality of judges. So yung pinakauna pong in-explain dito nila Attorney Kauffman is yung May 1, 2025 na final nga nila yung invitation lang ng judges to excuse themselves. So dito po makita natin, sinabi dito ni Attorney Kauffman that the defense is fully aware that such an invitation is not contemplated in the statutory text. The defense emphasized, however, that it was motivated by a sense of courtesy and deference precisely because of the presumption of judicial impartiality and integrity. So in short, ginawa daw nila yon out of courtesy or out of respect. Before nila file ng actual disqualification, gusto muna daw nila i-invite or parang bigyan ng notice yung judges para at least magka-opportunity sila to excuse themselves without actually filing the disqualification case proper pa. So again, ulitin ko lang, in-emphasize ng Attorney Kauffman na alam nila na wala daw yun sa batas pero it is a matter of courtesy lang daw po. Okay? Tapos yung next po, in-emphasize din ng Attorney Kauffman na sa Rule 35 daw ng Rules of Procedure ng Rome Statute, it states there that Rule 35 makes it clear that where a ground for disqualification exists, a judge shall not wait for a defense request. So basically again, kaya nila sinabi yung invitation una is parang notice nga lang yun or courtesy na since mukhang may ground ka for disqualification, wag na daw nila antayin na ma-disqualify pa sila kasi pwede naman daw silang mauna yung judges na mag-request na to excuse themselves. So yan po yung next dito na ginamit nila Attorney Kauffman, yung Rule 35 po of the Rome Statute. So if you read the Rome Statute po, Rule 35 that is stated there, ito pong ganitong reasoning nila Attorney Kauffman. And then kung makikita natin yung next sa paragraph 4 on 6 May 2025, the pre-trial chamber dismissed the defense's invitation. So yun yung in-explain ko na kanina yung pinakauna pa. So again, sinabi nila Attorney Kauffman dito, they were fully aware but it was a matter daw of courtesy lang na mag-invite muna sa judges na baka gusto nila mag-excuse sila before any petition for disqualification will actually be filed against them. Okay? Tapos yung pinaka-main issue po na ni-raise dito nila Attorney Kauffman is ito po yun. The question before the presidency is whether in the present scenario there can exist a public and objective perception of impartiality when the judges have already ruled on exactly the same issue in exactly the same situational context. So yan yung in-explain ko sa inyo kanina, 'di ba? Yung dalawang judges na gusto nila ipa-disqualify, naging involved na dun sa appeals chamber. Therefore, pwede ngayon magkaroon ng appearance of partiality on their part kasi hindi po nila ginrant yung appeal dati. Pinabura nila na may jurisdiction daw talaga. 'Di ba yung sa defense po nila Attorney Kauffman, they are questioning basically jurisdiction over the subject matter and the exercise of jurisdiction. So yung dalawang po yun touches also on jurisdiction. Therefore, since kasama na yung dalawang judges na to dun sa appeals chamber, according to Attorney Kauffman, posible daw maapektuhan yung impartiality and the appearance of impartiality ng two judges na yon in relation to that issue. Okay? So yan yung pinaka main argument talaga nila na nagre-revolve around. Tapos after po niyan actually, ngayon inisa-isa pa to nila Attorney Kauffman yung elements ng requirement para magpa-disqualify. So ngayon isa-isahin din po natin. So yung unang requirement po dyan is the degree of congruence between the legal issues. So congruence means similarity, di ba? So in simpler terms, ibig sabihin po nito yung degree ng pagkakaparehas ng dalawang legal issues. Yan yung first requirement. Then pangalawa dyan, whether yung factual determinations would be based on the same evidence. Kung same lang yung evidence na ginamit dun sa luma, tapos ngayon yung same issue na gusto na desisyonan will use the same evidence. Okay? And then yung number 3 dyan is kung yung judge ba is free to depart from previous factual findings which he or she made upon consideration of the same issues and evidence. So in Tagalog, ang ibig sabihin po niyan, kung kaya ba ng judge na ibahin pa yung decision niya considering the circumstances po of the case. So yan po yung 3 requirements. Una yung degree of similarities between the issues. Pangalawa yung evidence kung parehas ba. At pangatlo kung kaya ba talaga ng judge na or kung mukha bang kaya ng judge na baguhin pa yung decision niya despite yung previous na factual findings or decision po niya. Okay? So as to the first requirement, yung degree of congruence between the legal issues, ang sabi po ni Attorney Kauffman, merong prior involvement yung judges daw in the most substantive legal questions in the case against Mr. Duterte. Kasi yun nga, yung diniscuss before was jurisdictional issues. Ngayon yung defense nila also touches on jurisdictional issues. So kung titingnan po natin, there is really a congruence or similarity between the two issues po. Okay? So as to the similarity in the evidence, the factual determination would be based on the same evidence. Ang sabi din po ni Attorney Kauffman dito is that no new facts will arise which would possibly allow the judges to reflect differently upon the legal issues at stake other than to maintain their previous findings. Kasi more or less same naman eh. Timelines lang po yung pinapag-usapan nila, di ba? Yung date of withdrawal, yung date of filing ng investigation versus dun sa mga preliminary matters na ginawa noong 2018. So since puro lang po dates pinapag-usapan, more or less parehas lang po yung evidence na gagamitin. Therefore, magiging parehas lang din yung factual determinations of the issue. So yan po yung second argument dito nila Attorney Kauffman in relation to the second requirement. Okay? So ang pinaka-important po talaga dito sa 3 requirements na to is kung kaya ba baguhin ng judge yung decision niya despite dun sa previous decision niya that touches on the same legal issues and has the same evidence po na ginamit. So ngayon, tingnan po natin kung paano yan inargue nila Attorney Kauffman. So as to the third requirement po, yung opening statement dito nila Attorney Kauffman, sabi nila, it is not reasonable to expect a judge who has recently expressed a highly publicized position on a specific legal issue to depart from that view. Okay? Kung ako po tatanungin, I agree with this position. Lalo na po 'di ba na yung case ni FPRRD is highly publicized not only in the Philippines but on the international level po. So therefore, if you are a judge who previously touched or decided on a certain issue with the same issue now, mukhang mahirap naman kung questionin mo sarili mo kasi magmumukha kang 'di ba, inconsistent yung statement or legal position mo. And ako, I agree dito na a reasonable person would not expect that judge na babaguhin niya. Lalo na po talaga na yung case ni FPRRD is a highly publicized case po yan. Again, not only on the local level but also in the international level. Okay? So kung ako po tatanungin, actually yung magandang dito, yung magandang discussion para makita talaga natin kung a reasonable person ba would whether or not expect a judge in this situation na i-overturn yung sarili niyang earlier decision, is maganda po kung sa comment section siguro po ipaalam ninyo yung thoughts ninyo, kung tingin ba ninyo in a highly publicized case kung saan hinawakan niya previously, posible bang magbago yung decision or yung mindset ng judge na yun later on. So I think one of the best ways for us to determine this is kung maki-involve po kayo sa comment section. Let me know your thoughts po kung ano tingin ninyo. Kasi kung titingnan po ninyo, ang sabi dito ni Attorney Kauffman, a reasonable observer is defined as an informed person with knowledge of all relevant circumstances, including traditions of judicial integrity and impartiality. Okay, so in-explain ko naman na sa inyo, 'di ba, kung ano yung reason bakit a judge must not only be impartial but must also appear to be impartial. Tapos I'm sure if you are watching this video na informed din kayo of the knowledge and all relevant circumstances of the case. Therefore, qualified po kayo maging reasonable person to determine para masagot po yung question na sinabi ko. So let me know lang po sa comment section kung anong thoughts nyo regarding this issue. Whether or not a reasonable person would expect a judge who has recently expressed a highly publicized position on a specific legal issue to depart from that view. Kung sa Tagalog pa, kung sa tingin ba ng isang reasonableng tao, yung judge na nag-decide na on a previous matter is babaguhin pa ba niya yun in a later case kung saan yung kasong yun is highly publicized not only on the local level but on the international level as well. Okay? So ito medyo maritesa na lang to, pero curious lang din ako kung ano talaga yung thoughts po ng mga viewers ko regarding this issue. And then on the part of the prosecution, ito i-share ko lang din po kasi maganda rin tong argument ng prosecution regarding dito po sa ni Attorney Kauffman. So sabi po ng prosecution dito is that the judge's prior legal determinations on legal issues made in the course of carrying out their ordinary duties do not amount to bias, nor should they create the appearance of conflict of impropriety. A conclusion to the contrary would lead to a nonsensical situation where a judge may be barred from issuing decisions on the same legal issues more than once. So basically yung point dito ng prosecutor is hindi daw pwede argue na porket naging involved before, hindi siya pwede maging involved later on with a similar issue. Otherwise, ang dating niyan ngayon is hindi pala pwede mag-decide yung isang judge on similar issues. So kung makita po ninyo, yun yung argument naman ng prosecution. Ang problem ko lang po sa ganitong argument, hindi naman kasi the same legal issue yung pinaka-issue talaga regarding this. Rather, ang pinaka-issue po dito is that there is a similarity in legal issues, there is a similarity in evidence submitted, and the issue on whether or not kaya by overturn talaga ng isang judge yung prior decision niya na maging contrary dun sa una po niyang decision considering the circumstances of the case. Dito kasi yung prosecution, he made it appear na sobrang simple lang na dapat kahit same legal issue pwede pa rin mag-issue yung judge. However, yun nga, hindi, like what I stated, hindi po yun ganun because this case is highly publicized, so may other circumstances ba revolving around the case na it is not as straightforward na legal issue lang talaga yung pinapag-usapan. Kaya nga po meron nung third requirement, diba, whether or not a reasonable person in that situation is tingin niya yung judge kaya ma-overturn considering all the circumstances of the case and not only on the similarity of legal issues. Okay? So I'm sure mababash ako dito kasi mukhang pro FPRRD ako, pero kung ako po tatanungin, honestly speaking, yun po talaga yung observation ko dito kasi itong prosecution, kaya nga sabi ni Attorney Kauffman the prosecution misrepresents the defense arguments. Diba? And I agree with this kasi the prosecution is making it appear na yung issue lang talaga is similarities in issue, which is hindi po yun lang naman yung issue talaga regarding this, yung mga disqualification of judges. Because again, judges must not only be impartial but they must also appear to be impartial. Very important po talaga yun. Okay? So in conclusion po, ang sinabi talaga ni Attorney Kauffman is this one, kung makikita po ninyo. The question of jurisdiction and the exercise thereof is a contentious, if not the most contentious issue in the case. Deciding this matter in favor of the defense will have far-reaching consequences on the future of the situation. Okay? So ang point po nito, kung sa Tagalog pa, yung question of jurisdiction or yung mga issues of jurisdiction is seryoso daw po yun or very material sa case, if not the most serious or the most important daw in the case of FPRRD. Kaya dapat daw ma-actionan talaga siya ng isang impartial judge. Not only an impartial judge but a judge that also appears impartial in the eyes of a reasonable person. Kaya inaano talaga nila Attorney Kauffman yung petition for disqualification, yung request po nila for disqualification, because basically kung magagrant to or madedenay, this will really decide the fate of the case po of FPRRD. Kung magrant to ngayon, hindi naman automatic mananalo agad si FPRRD sa case. Okay, klaruhin ko lang din po pala yon. Ang mangyayari lang, madidisqualify ngayon yung 2 judges na yon na na-desisyonan na yung similar issue. Therefore, may papasok na 2 judges, may fresh minds po na mas magmumukhang impartial talaga yun sila in the eyes of a reasonable person. So sa ganung situation po, mas magiging mukhang patas po yung decision. So again, i-clarify ko lang po hindi po porket na i-grant tong request for disqualification, ito is automatic panalo agad si FPRRD. Ang mangyayari lang po, may bagong judges na ma-assign na hindi naging previously involved. So in that sense po, mas magiging mukhang patas na yung kaso. Okay? And again, the reason kung bakit nga ito pinupukpuk talaga nila Attorney Kauffman is because very important talaga yung defense of jurisdiction sa kaso ni FPRRD. Like what they have previously explained po dun sa May 1 defense na final po nila, na in-explain ko din po yan sa previous videos ko. Anyway, kung gusto nyo po talaga makita kung bakit importante talaga yung jurisdiction dito sa defense, is ilalagay ko na lang po dito sa gilid ng mukha ko yung video ko regarding that para mas ma-appreciate nyo pa po yung case. Okay? Pero for now kasi hanggang dun na lang muna tayo So anyway, hopefully klaro po yung discussion natin despite the technicalities. So if you like legal educational videos, follow lang po kayo sa akin. Until next time, see you all po. Bye-bye!